I'm here to present the Faulkner versus National Geographic Society for the ownership of photographs and copyright infringement. So the facts are that the National Geographic Society has approximately 10 million members, and it's the world's largest nonprofit scientific and educational organization. And the plaintiffs had taken images and allowed the magazine, the National Geographic magazine, to print it on it. They had a contract that gave the magazine the copyright to the images. The dispute here is related to what rights the magazine actually had to use their work and for what and when and how, etc. So they initially granted the National Geographic Society the right to publish in the magazine, but later on the pictures were also published in the digital version. So the issues from there on, and this is the legal analysis. So in 1996, the National Geographic decided to digitalize the magazine issues from 1888 to 1996 into a CD. And then the product was called the Complete National Geographic, the CNG, and it was 108 years of National Geographic magazine on one CD, which was one of the first digitalized issues that they sold. Well, the first one that they sold. The plaintiffs alleged that the National Geographic had violated Section 201C of the Copyright Act because there was no permission to use these works except in the print magazine. So that leads to copyright infringement. And then National Geographic replied saying that they used part of the Section 201C, which talks about revision and reproduction. And it states that copyright in each separate contribution to a collective work is distinct from copyright in the collective work as a whole. Invests initially in the author of the contribution. So then what happens next is National Geographic states that the magazine, the digital magazine, is a reproduction or a revision of the original work, and therefore they are fully allowed to use the works since it was from the same purpose. The plaintiffs then stated that the magazine itself, the digital magazine, could not use Section 201C of the 1976 Act because they litigated and lost the same argument on Greenberg versus National Geographic Society. So therefore, they asked for collateral estoppel when the same issue in the proceeding has already been litigated and decided on. The litigants had a full and fair opportunity to litigate and ordinarily do not have a right to relitigate an issue that has been decided against them in a prior action. So the key differences between these cases, though, is that in the Greenberg case, images had been put in a moving animated cover with music in the background, in addition to other pictures that he had taken just being featured in the digital magazine. So in the ruling in the Greenberg case, it was first ruled in the favor of the defendants, and then it was appealed, and then later ruled in favor of the plaintiffs, which are the freelancers, because the issue had been modified to a certain extent that the 11th Circuit saw it as an entirely new work, which revoked the rights to the works. However, in the Faulkner case, there was no added animation or illustration or music to the previous pages and photos, and therefore the court decided that the issues are not identical. So the court decides not to use the application of collateral estoppel. So then the decision on March 2005, the U.S. Court of Appeals for the Second Circuit confirmed that they were dismissing the copyright claims against the National Geographic because the publication in a computer accessible format is also permissible under the Copyright Act as a reproduction of the old magazine. In the Greenberg case, it was once ruled in favor of the plaintiffs in 2001, saying that the National Geographic broke the law. And then in 2007, after the first decision in 2005, the 11th Circuit revised the decision and reversed the decision and had the case reheard by the 12 judges. In June 2008, the 11th Circuit ruled that the National Geographic Society was protected on the reproduction of the entire original work. So in both cases, later on, National Geographic was protected and remained in the rights of the copyright of the work that they reproduced. So basic questions here. Why would a freelancer go after a magazine towards copyright infringement if they signed a contract in the first place? And this is a complicated question, since there could be many reasons why a freelancer would go after a magazine or an issue. But however, in this case, it was argued that they were looking for extra payment. So since the digital magazine was a different type of issue, they were arguing that they needed to get paid again so that they could use their images again. Second question would be, why did the court reverse the decision in the Greenberg case after a couple of years? And then the third question would be, how does copyright laws change from print to fully digitalized works? And that's it. Thank you very much. And this is the works cited. Yep.